Yes. May it please, my lady, my lord. I will address the court first on jurisdiction, on the basis that absent jurisdiction, the court is unable to hear the appeal or to deal with the merits, and that is the start and end of the matter. I then turn to the appellant's grounds 1 and 2 in the form consistent with the way in which the judgment dealt with them. The court is invited to refuse permission on each ground. Learned friend, Leonard Junior, Miss Foote will address the court on ground 3 in the same way that Miss Townsend did for the appellant. In summary, if I may, the respondent's position first on jurisdiction is that this is a clear example of a criminal causal matter because the respondent remains in jeopardy and was in jeopardy at the time of the minister's decision.
Not as a result of that decision.
Well, pursuant, if I may say so, in jeopardy pursuant to underlying foreign domestic criminal proceedings that are current, remain current and live and are pending both in Portugal and in the US, and the extradition proceedings themselves are criminal proceedings that remain ongoing.
Yes.
The extradition process being predicated on those.
So if the Secretary of State didn't have to choose between them, the underlying extradition proceedings would, one way or another, result in a criminal trial. That's right, isn't it?
Yes.
But so what? Because the Secretary of State has to carry out an executive function of deciding which of these two sets of proceedings takes priority,
yes.
And that does not in itself result in his incarceration or exposure to criminal process. The extradition warrants do.
Yes, and
that would be the case anyway, regardless of this decision.
And my lady, in my submission, the minister's decision is integral to that extradition process in determining where the respondent will be in jeopardy, where he will face trial, and importantly, this decision of this minister impacted on which offences he will face trial on. And this impact the minister was unaware of due to his factual error and the misinformation that he understood. And so the court does have to focus on the facts of the case before it, and therefore it's important to answer my lady's question that the nature of the jeopardy, the form of the jeopardy, is different depending on which jurisdiction this requested person is being sent to. And if one just stands back and looks at the matter with some perspective, one can readily see in my submission for anyone facing either a trial in their home country or their nationality, where their family is based and where the support mechanisms are in place, or a different continent, a foreign, distant legal system, very far removed from one's family, that is a highly material distinction. And indeed, the nature of those different systems may well be materially different. So a direct effect and consequence of the ministerial decision is that the respondent would face materially different offences in two rival jurisdictions, additional criminal conduct in Portugal, where he would thus be in jeopardy before the court of his home country for separate punishment pursuant to those different offences. And in my submission, it is material, it is significant, it is extraordinary in my submission that the minister was blissfully ignorant of that.
Well, all that's very fine rhetoric, but it doesn't really help with respect in determining the question of jurisdiction. The question of jurisdiction must apply across the board regardless in any case in which the Secretary of State has to make a decision of this nature under this particular section of the statute, irrespective of whether or not it has certain consequences in certain cases. Either that kind of decision is a decision in a criminal causal matter or it isn't.
Yes, and I...
So I think we would be more greatly assisted by submissions as to why you say this type of statutory decision or this function that is exercised by the Secretary of State results in the fulfilment of the relevant test in McGuinness.
Yes, and I was going to come on to that. With your leave, I was just going to briefly point out that the key tests arising from McGuinness, upholding Armand, or Amand, is that one focuses on the nature of the underlying proceedings, both here and abroad, the fact that they're pending and their currency, and the direct effect of the ministerial on those proceedings. And it's clear, just to give another practical illustration of the point I'm making, that if the request person here, the respondent, were to face trial first in Portugal, it would be unnecessary for him to face further trial in the US. Whereas if he faced trial first in the US, there would still be outstanding charges for him to face in Portugal. So there's a direct material difference to the nature of his jeopardy, to the duration of his jeopardy. And one has to approach this from an intensely factual and practical standpoint in my submission. If I can just briefly summarise my case with respect to the merits of the Secretary of State's appeal. In my submission, in what was a comprehensive and measured, most careful judgment, the court recognised that the Minister had a public law duty to act fairly towards the person directly impacted by the decision, to notify him of the decision being made, the timing of it, and to afford him an opportunity to be heard by receiving relevant representation. And that is summarised in the judgment at paragraphs 86 to 89 in reliance on the leading canon of case law, the judgment of Lord Justice Singh in Citizens UK, paragraph 68 of that judgment, Lord Musterlin Doody at page 560 at letter D to G, and in Bank Mellet, the judgment of Lord Neuberger at paragraphs 178 to 9. And I do emphasise that the requested person may have information uniquely in his possession for the purposes of a proper, sound and accurate decision being made, which may be relevant to that decision being reached, both as to the statutory mandatory listed issues and the other matters which the statute expressly envisages by not excluding other considerations. And in particular phraseology, the Minister may benefit from that input, that factual input, to cure factual errors that may otherwise have vitiated the decision. And the context here is that the factual errors in the Minister's decision were, in my submission, fundamental and material to the decision. And we see that from the Secretary of State's own materials at Bundle 2, page 9, paragraph 10, under the heading Key Points for Consideration, where it was recognised that the first mandatory criteria, the comparative assessment of the relative seriousness of the offences, will usually determine which case claims precedence. And so that is telling in terms of the materiality issue for this court. On the first statutory consideration, yes, so the facts of the additional conduct being prosecuted in Portugal as compared to the US were we know not made available to the Minister because he was not given, did not ask for the basic US request or the basic Portuguese warrant that he was supposed to be comparing to conduct a careful, accurate comparison. We were not aware of this at the time. We relied on, in good faith, on the Minister's skeleton argument in the judicial review hearing, confirming the Minister had these source materials, until Miss Justice Linden flushed this out after the hearing. The Minister's, yes, and Miss Justice Linden found at paragraph 147, that's the bundle 1 at page 83, if I can just turn that up briefly.
Bundle 1?
Yes, bundle 1, page 8, it's a judgment of the Minister of Court at page 83, the lady of the bundle.
That's in the core bundle.
Yeah, that's right. Paragraph 147. It said there that the Portuguese authorities had charged the claimant with additional offences based on additional criminal conduct. In effect, both the request and the warrant require him to stand trial for data theft and trading instead of data. The warrant additionally seeks to prosecute him for the laundering of the proceeds and the failure to account to the Portuguese tax authority for these proceeds. Moreover, this feature of the warrant is specifically connected to Portugal. In relation to the money laundering, the warrant alleges in terms that the proceeds of the claimant's activities in relation to raid forms were paid into his Banco Santander account in Portugal in relation to tax fraud. The allegation is that the claimant was never registered with the Portuguese tax authorities and has never submitted income tax declarations to them. And so I just pause there to emphasise that notwithstanding these somewhat fundamental factual errors, no endeavour has been made to make a fresh lawful decision over 25 months later. The respondent came to the UK from his home in Portugal to attend to his terminally ill mother, who has since died during the currency of these proceedings, after a traumatic childhood in the UK, which is documented in the report. He's since been stranded here, unable to work or to move forward with his life for 4 years, since January 22 when he was arrested. And so the impact of the proceedings on the respondent have been profound. He's receiving treatment for his fragile mental health pursuant to Home Office support arising from its acceptance that he was a victim of modern slavery from when he was living here in Croydon in relation to these very allegations. The court has before it updated medical evidence and I respectfully invite the court to consider it bene esse without objection from the appellant. It arose, this evidence, organically from the ongoing treatment which he's been receiving since June 25. It can be seen that his mental health has taken a profound turn for the worse, that on the 16th of April, just a few days ago, an urgent referral was made to his GP from his therapist, who considered him to be an urgent safeguarding risk due to active suicidal intent. And it's explained at page 3 of that that he's invested in his therapy. The enduring nature of his case is proving to cause him severe exacerbations in his mental health, and he has an active suicidal history which is currently active. And we then have the report addressing this from his therapist, Ms. Selina Brown, confirming that he was assessed as having severe complex PTSD, severe major depressive disorder, and severe generalised anxiety disorder, as well as a suicidal ideation. And so, given the live issue of the interests of the respondent being challenged, which was deemed relevant and important by Mr. Justice Linden, this does help the court by showing the ongoing impact of the prospect of extradition to the US and the unnecessary delays arising from the minister's appeal to the wrong court. And so, turning then to the issue of jurisdiction, if I may, the preliminary issue should be considered from the perspective that the minister who complains of delay as the overarching policy objection to fairness to the requested person, has in fact introduced substantial delay by seeking to invoke this court's jurisdiction alongside, in tandem with an application to the administrative court to certify a point of law for the Supreme Court to decide.
The Secretary of State is entitled to appeal to the appropriate court, if it is the appropriate court, if he or she comes to the conclusion that the judge got it wrong. Yeah. That's all built into the fact that there is a judicial review process. Yes. If you started the judicial review process, you can hardly complain that the Secretary of State has availed herself of a right of appeal, subject to it being in the right place.
Well, my lady, I would just say I've never heard of an appeal being lodged both in the administrative court and in the Court of Appeal at the same time, and it suggests the Secretary of State was herself unclear as to which the correct form was.
Well, I've certainly heard of that.
Yes,
more than once.
Yes.
And it's safeguarding against the view that her submissions may be rejected.
Well, very well. I would, in my submission, submit that it's important that when one considers the range of challenges to decisions made in the context of the 2003 Extradition Act, that the outcome has consistently been that the decisions are taken to the administrative court and generally, as a rule of thumb, end there, because where there's no point of law certified, that's the end of the matter. And so that it does introduce an element of efficiency, expedition and speed to the proceedings, which is particularly important where there's a vulnerable person behind.
It depends on the nature of the challenge, doesn't it? I mean,
Indeed.
if it's a challenge to an extradition decision, then that's the end of that. And it's hardly likely to raise a point of law of general public importance. But this is a challenge based upon the proper application or the proper way in which a statutory, a decision of Parliament statute is to be interpreted and how it's to be applied.
Yes, and
By somebody exercising what can only be described as an executive function and not a judicial one.
yes, my submission is that the 2003 Extradition Act was designed to prevent additional unnecessary layers of challenge and appeal, and it did not intend for this situation whereby a High Court decision can be challenged twice on appeal, first to the Court of Appeal, then to the Supreme Court. That is entirely inconsistent with the scheme of the Act. Statutory extradition appeals are heard by the Administrative Court and the Supreme Court only. Yes, well, the distinguishing example is the Guardian newspaper's challenge to the district judge's decision not to afford access to skeleton arguments so that the media could understand what the case was about in court. And that was an example of a collateral challenge that didn't involve a criminal cause or matter. But when one looks at the full range of decisions which go to the actual extradition proceedings, the substantive issues along that chain of decisions that take place during the course of an extradition process, one sees they all consistently are dealt with as criminal causes or matter when judicial reviews are brought, which mirrors the statutory scheme of the substantive appeals only be dealt with by the Administrative Court or the Supreme Court. And so, if I can address, my lady, as to the relevant test, the essence of the test was formulated with commendable clarity in the House of Lords judgment of Amand by Lord Wright at page 162. That's bundle page, authorities 2352. If I can just bring that up briefly. Yes, it's just in the middle of the page. The principle which I deduce from the authorities I've cited and the other relevant authorities which I've considered is that if the cause or matter is one which, if carried to its conclusion, important phrase, might result in the conviction of the person charged and in the sentence of some punishment, such as imprisonment or fine, it is a criminal cause or matter. The person charged is thus put in jeopardy. And so might the Minister's decision here to surrender the respondent to the US instead of to Portugal, if carried to its natural conclusion.
Her decision was to defer. She doesn't have a power to promote anything. She has a power to defer one of two sets of extradition proceedings.
So she's deferred to the Portuguese decision.
Yes, and my Lord is entirely right to pick up on the statutory language.
So the effect of that, the effect of deferring the Portuguese decision is he's not exposed to criminal proceedings in Portugal.
Yes.
It means that if he's exposed to criminal proceedings at all, it's under an extant warrant that was lawful in favour of the US, which the Secretary of State has had no hand in. And could have no hand in. Yes,
and the significance, my lady, I take from this analysis of the correct application of the test is that the focus here is on the outcome and what the requested person is exposed to. And all that matters, and I submit that there's a risk of overcomplicating it, all that the courts are concerned with is whether the outcome, when carried to its natural conclusion, will result in jeopardy, exposure to charge or punishment. And so it matters not that there may be intermediate steps between the decision being taken and the jeopardy that one is exposed to. It's simply the conclusion, the ultimate natural conclusion that matters.
I'm sorry, but it has nothing at all to do with surely there is no causal connection between a decision to defer a Portuguese arrest warrant and somebody's exposure to criminal proceedings as a result of an American arrest warrant. He is exposed to that whether or not the Secretary of State does anything.
Well,
so how can it be the outcome of her decision that he is exposed to criminal proceedings in America?
Well, in my submission, the consequence of deferring Portuguese warrant and surrender on that warrant is that the requested person is, as a consequence, facing jeopardy before the US criminal jurisdiction.
So that would occur in any case where the Secretary of State has to make a deferral decision?
No, because if the US request was deferred, he would be exposed to jeopardy in Portugal, which gives rise to...
He'd still be exposed to jeopardy?
Different jeopardy, materially different jeopardy.
So what?
Additional offences.
The question is he going to be, if carried to its conclusion, will he be exposed to jeopardy? On either analysis he must be, on your case.
And that's why the test is satisfied, because he is being exposed to jeopardy as a consequence of the underlying extradition proceedings, as a consequence of the live criminal proceedings.
So your analysis depends upon the decision of the Secretary of State, whichever way it goes, having the effect of exposing him to a jeopardy that he's already in.
It's a decision which is part and parcel of the process which exposes him to jeopardy, and that is enough. Okay. And to look for more than that is to take a wrong turn in my submission. One isn't trying to add an additional formulation that the minister has the power to discharge the requested person outright. It's a continuation of that jeopardy and a material decision pursuant to that jeopardy that is an issue. And so the speech of Viscount Simon in the same case at page 156, bundle page 346, formulates the test as being that the matter is one, the direct outcome of which may be trial or the applicant and his possible punishment for an alleged offence by a court claiming jurisdiction to do so. Well, that is part of the outcome of the extradition process and the minister's decision. And the court in McGuinness, the Supreme Court in McGuinness, at paragraph 77, bundle page 497, reaffirmed and upheld the test formulated by the House of Lords in Remand.
Yeah, well, the test in full, if one looks at page 497, are they proceedings the direct outcome of which may be trial?
Yes, I'm sorry, which?
Page 497, paragraph 77, McGuinness.
Yes.
Lord Sales, the classic example of exposition of amende. The question is, are they proceedings the direct outcome of which may be the trial of the applicant?
Yes, and so that's exactly my point, lady. That
there are no proceedings before the Secretary of State, are there?
That one looks at the underlying proceedings, and the status of those proceedings don't change. They remain criminal. This is part of that criminal process, and that's the focus, and that's why all of the extradition judicial reviews remain criminal causes or matters, unless the media seeks to intervene on a collateral matter, for example. And so, looking at paragraph 78 of McGuinness, the following paragraph to which my lady's just referred, one sees that the challenge there is qualitatively different to what one is dealing with in the context of the extradition proceedings. It's a challenge to the Department of Justice's interpretation of a sentence imposed on Mr. Stone in the past. So, crucially, the criminal process against him was exhausted before the ministerial decision under challenge was made. Accordingly, the challenge did not relate to the commencement or conduct of any underlying criminal process involving Mr. Stone. And he was not currently the subject of any outstanding or undetermined criminal charge on which he was to be tried and be subject to sentence. So I invite the court to recognise that the currency of the criminal proceedings underpinning the cause or matter before the court is key.
Well, that's certainly one of the reasons that Lord Sales said that it was not a criminal cause or matter. What do you say about para 80?
Yes. Paragraph 80.
Mm-hmm. Because that's the second limb of Lord Sales's justification.
Yes. Yeah. So what I say is that the in response to that is that all of the judgments have consistently recognised that where the underlying process is in essence criminal, and it's accepted that that's the case here by all parties, the intention of Parliament and as consistently reflected in the case was to limit the appellate rights to one appeal, and so that is a complete answer to the point, my submission that has been made there. This has not been made in the criminal or extradition context. But just to complete the point I was addressing the court on, that it does, my submission, matter where the proceedings are unresolved in deciding whether they concern a criminal cause or matter. That's why in the case of McGuinness, one saw there was a resolution. It wasn't a criminal cause or matter. It was an ancillary matter post-trial, post-sentence in relation to the licence. And that is why the key points from McGuinness in my submission are focus on the underlying proceedings that the High Court is addressing instead of the abstract categorisation of the proceedings in the High Court itself, which is the language used. And the word matter, quotes, does not refer to the subject matter of the proceeding, but to the proceeding itself, as Lord Wright explained in Amand. And so, in order for the proceeding in respect of which the High Court is addressing to be criminal cause or matter, two conditions must be satisfied. To recapitulate per Amand as upheld. One, the applicant is put in jeopardy of criminal punishment by those proceedings, and secondly, such jeopardy is the direct outcome of the underlying proceedings. And so then, if I can then address apply these principles to the respondent's case, in contrast to McGuinness, here in the respondent's case, the criminal proceedings are pending, ongoing at the time of the decision and now, in both Portugal and the US, and may result in his future trial or punishment, such as he's put in jeopardy. The decision of the minister, giving rise to these proceedings, goes directly to the issue of those pending trials. It determines in which country that trial should take place. Here, that will impact on which charges he will face, for which he is in jeopardy, to address the Amand test. And it becomes relevant here, pursuant to the approach of the administrative court in the judgment of Mr. Justice Linden. For example, when the court is addressing the non-mandatory criteria, the other factors, that in context of the mental health issue, that the ability of the requested person to survive the trial, and therefore the viability of the trial itself, important matters. They matter to the victims in seeing justice being done. They matter to the ability of the requested person to take part in that trial. And if I may just briefly refer court to the decision in Larry Love against the United States of America, where the court was addressing trial forum issues in a different context, in the statutory appeal context, under issue of oppression, but also under the issue of the forum bar. It's page 269 of the bundle. One paragraph. Well, if I can just first of all refer to the court.
We had the time to actually turn it up, please.
I'm so sorry. Oh, yes. So it was page 268.
269.
Well, if I can, perhaps I just start at page 268. Just above paragraph 33.
Yes.
The court recognised there that Mr. Love was fit to stand trial at the time, but the consequences of his removal to the US, removal from his family and support network, in view of his precarious mental health, gave rise to a real risk that he would not be fit to stand trial in the US. And then at 33, the court
this is an appeal, and this is
statutory appeal.
A statutory appeal in an extradition matter. Yes.
And so the court here found that we did not consider this can be dismissed as conjecture. It's not. It creates a significant risk factor and tells against extradition being in the interest of the victim to the extent there at least a significant risk there would be no trial at all. The circumstances in which there would be a risk that Mr. Love would not cope with the trial proceedings were far from speculative. Then at 43, just over the page, paragraph 43, at the foot of page 269, one sees here, there's, on the third line, there is particular strength in the connection to his family and home circumstances provided by the nature of his medical conditions and the care and treatment they need. This is not just or even primarily the medical treatment duties, but the stability and care which his parents provide. This could not be provided abroad. His entire well-being is bound up with the presence of his parents. This may now have been enhanced by the support of his girlfriend. The significance of breaking those connections, as we come to next, demonstrates their strength. And so one sees here an example of the court understanding the significance, the relevance of these features to conducting an appropriate decision where there are two possible trial forums, and one is not in a situation where there's a risk of impunity or the trial not being carried out, but an alternative where the trial can take place in two different places.
Mr. Cooper, if you're right, and we've read the medical evidence and fully aware of the position of the respondent, but he can rely on all that in the extradition proceedings to make a case that he should not be extradited, can't he?
Well, that's exactly what Mr. Justice J found he could not do in his order, which I can take my lord to.
Yes, do.
Which is why I say to the court, one has to focus on the particular facts of this case that the court is seized of when deciding these points of law, because they do illustrate the problems. It's bundle 2 at page 362. Which is tab 6J, where this respondent endeavoured to do precisely what my lord envisaged could be done in the statutory context. So at the time of the...
Tab 6J.
Yes, page 362.
This is supplementary.
Bundle 2, yes. Thank you.
Right. Have you appealed that decision?
So that appeal is stayed. The
appeal is stayed, so you have sought to appeal it.
So there's a renewal application outstanding.
Right.
With respect to that, which has been stayed because Mr. Justice Knowles and Mr. Justice Chowdhury recognised that this judicial review had to come first.
I understand. So just to get my head around so if Mr. Justice J was wrong, there's still a means of putting him right.
So which part?
Yes.
Which part of the decision?
So it's really it's page 362 on the proposed amended grounds of appeal. That's where we tried to persuade the court of the relevance of the new factual development of the new Portuguese arrest warrant, giving rise to an alternative trial form than the US, in the context of District Judge Sternberg finding that it couldn't be relevant. Possible trial in Portugal couldn't be relevant because there were no criminal proceedings in Portugal.
So the competing arguments, as it were, between the two jurisdictions.
Yes, and one sees here that Miss Justice J says this must be raised in the JR proceedings rather than in the extradition appeal.
That's not the point. He's saying that if what you're complaining about is the preferment of the United States as a forum over Portugal, you must do that in judicial review proceedings. He's not saying, if what you're saying is that it would be a violation of his Article 2 right to live to be extradited to the United States of America. You can't raise that in extradition proceedings.
Well, the statutory position there, my lord, is set out in, I can just take, my lord, to section 104 of the Act. This is Authorities 1.
Yeah.
Page 290, where my lord will see section 104 of the Extradition Act, which sets out the powers on an appeal under section 103, which is what Mr. Justice J was dealing with when he refused permission. And sub 104 subsection 4 provides the hurdle the requested person has to overcome. So the issue or evidence, this 4B, would have had to result in the judge deciding the question before him at the extradition hearing differently. So the new evidence has to be decisive in establishing the district judge approached an issue before him incorrectly. And the real point in answer to my lord's question, and this is fundamental to this whole appeal, and if I may say so, Mr. Justice Linden grasped this matter correctly in his judgment by recognising that there is a qualitative difference between a decision being made by a minister under section 179 of the Act to a court that is conducting a binary decision-making exercise of saying, is it legal or not to extradite someone to country X? And so what the new situation gave rise to was an entirely new issue, an entirely new circumstance. And that is why the court below recognised that in conducting the 179 exercise, that the minister is not simply addressing matters that have been dealt with before by the appropriate judge.
Is what we were told this morning by the Secretary of State that human rights points can be raised up to the moment of execution of the extradition warrant. Is that wrong?
No. And so just as the court with this, that the historical position was that under the old Act, the 89 Act, these issues were dealt with by means of representations and judicial reviews. The 2003 Act ensured that issues of human rights were dealt with by the district judge and then the appeal to contain the matter. And then there's the issue of supervening factual development when the appeal is concluded. And there, the minister accepted, and this is Justice Morris J accepted in the McKinnon case, that where there was a supervening factual development giving rise to a human rights issue after the conclusion of the statutory appeal, the minister had a human rights obligation under Section 6 of the Human Rights Act to determine that. And there was then a judicial review remedy. Parliament then removed that whole process by amending the legislation by ensuring that where there was a supervening factual human rights development, the court would then deal with it instead of the minister. And so, therefore, the final human rights issue would be determined by the court if there's no alternative remedy, and one has to show that the evidence is completely new and hasn't been previously addressed by the court, and it would make it, and the court would reach a different conclusion on the human rights issue with the benefit of that new factual evidence.
Why wouldn't that apply to your client's very sad current situation, his deteriorating health and so on and so forth? Why wouldn't he be able to raise that under that process, given that the Secretary of State is precluded from considering human rights matters by the statute? So the legislative change was to stop the minister from dealing with fresh human rights issues that arose that could have been dealt with in the magistrates' court or the administrative court. What the legislation change did not purport to do
was to interfere in any way with Section 179. And so what is different about the competing request decision is the minister is being confronted with to go back to the point I was just making, a qualitatively new, separate, freestanding issue, which is notwithstanding the courts upholding the legality, potentially, depending on the timing of requests, of extradition to those countries. The minister has a decision to make which isn't fundamentally premised on human rights, but it's, as Ms. Just Linden explains, essentially deciding which is the most appropriate place to send this person to. And that is a broad discretion, given that the statute expressly allows for a non-exhaustive list of criteria, which can include other relevant issues and features to that decision. One sees from the minister's own guidance that under the nationality of the requested person is relevant to the location of the offence. Well, how have the courts interpreted the issue of nationality in this context? In the case of Lowry Love, we can see there the importance of that, where the family, where the support network can keep someone safe from a serious deterioration in their mental health. And so that's where the court recognised these features can become highly relevant to issues such as nationality and the immediate family being able to protect the defendant from a risk of self-harm or risk of deterioration. And what the Lord Chief Justice, Ms. Justice Ian Love, recognised that where there is an alternative trial forum, unlike in cases that have been dealt with previously, one isn't dealing with a risk of impunity or lack of punishment, but where is the most appropriate place for someone to be punished. And that's why the interests of the victims matter, because the victims would prefer there to be a viable trial, a concluded criminal process, a conviction, than no trial at all, which is an unsatisfactory outcome for everyone, and where the risk to the requested person is grave. The objective evidence here is that this particular respondent is acutely autistic, and that the objective studies have showed that the risk of completed actual suicide from autistic people diagnosed with autism of this nature is so enormously increased than those without that diagnosis. So this isn't a case of an ordinary requested person indicating that they can't cope with the process, but an underlying condition which itself heightens and exacerbates the suicide risk, where the support network is fundamental to the safety of that person. And here, what we have is a position whereby Portugal provides those safeguards, because that is where Mr. Coelho's family is based. And moreover, the Portuguese state provides those safeguards in terms of the expert support pursuant to its membership of the Trafficking Convention, whereas the US quite specifically expressly doesn't. And Ms. Justice Linden admitted the evidence of Enrique Salinas, the expert who made these points. That was the one expert evidence he thought was relevant and necessary to justly determine this matter, because it demonstrated the qualitative difference and the fairness of a trial in Portugal, where the defendant would be kept well and able to cope, as against the position in the United States, where he'd be very far from his family, from his those who can look after him, in a foreign, what has been described by the courts as a foreign alien environment in this context, and within a regime, custodial regime, where that in itself, as recognised in Love, exacerbates the risks because of the deployment of isolation rather than treatment. And so the US case in Love was, well, we'll just keep him in isolation, and that will keep him alive. And the court said, actually, he's going to have to come out of isolation, and the consequences of that isolation are such that it will have increased the risk of suicide and made him more vulnerable and increased the danger to the person. And so the point I'm making is that the minister, in making this decision, in deciding which is the most appropriate forum, is entitled to take account of all of these features, and these are important features, and in doing so, the minister is deciding something that hasn't come before in the extradition process. It's not an issue for the district judge. In fact, Judge Sternberg specifically found it wasn't relevant to his decision because there wasn't a Portuguese trial or warrant, and it's an issue which is uniquely given to the minister to determine at that stage of the process. And it's not envisaged, therefore, that the High Court will be the natural forum or the appropriate forum for that particular decision. And so, and in fact, when one considers the authorities on how relevant trial forum is to the extradition statutory process, the Supreme Court was pretty scathing of the relevance of that to the statutory issues, in saying it would be very, very rarely, if ever, relevant at all, which was the approach that Miss Justice Linden adopted as well. And so that is why I submitted this is a different, freestanding, separate issue. And it goes back to the jurisdictional point, my lady, if I may, because it shows the importance of the issue in the scheme of the Act. And so if the requested person can be safely in jeopardy in Portugal, where he has cooperated with the police, admitted his conduct, and is actively trying to help the authorities there secure justice, which is analogous to the situation in McKinnon, where, as one sees with quite often in the case of defendants diagnosed with autism, there's a degree of honesty that follows once they've understood the reality of what's happened. And so they're not fighting the trial or seeking to cause difficulties. They simply want to be held to account in order to move on.
I think the bottom line point, if I understand it, is that you say at no stage of the earlier stage of the extradition process has there ever been cause to consider, by reference to any factors, which of two competing jurisdictions is the more appropriate to the circumstances of the particular case. And in making that value judgment, it's important to take into account the factors such as support mechanisms, etc., etc. Yes. Is that the point?
Yes, and it's specifically envisaged by the TACA Treaty, by the framework decision that gave rise to our Section 179. I'll come on to this for just a moment. By the judgment of the CJEU, all of the courts and instruments directly recognise the essential feature of the interests and the circumstances of the requested person, which isn't surprising in the context of the canon of English natural justice case law, the duty case law, which recognises why it matters, why it's necessary to give someone the opportunity to be heard when someone is deciding their fate. And this, if I may say so, this case illustrates my point better than any, given Mr. Coelho could have ensured the minister's decision was at least accurate on the facts, which would have avoided all of the delay, over 2 years, in seeking to rectify those material factual errors.
What happens if you're right? What happens if the interested person puts in evidence which is disputed by the requesting authority? How's the Secretary of State going to deal with all that?
Well, again, that's dealt with in the judgment, and essentially what is said is that it's a paper exercise. So it's bundle page 78, paragraph 129, Roman 2. As far as delay and the practical implications of committee representations are concerned, the reasoning, paragraph 122 to 4 as it applies, it is open to the Secretary of State to set a tight timetable. In many cases, the issue will arise at a stage before statutory deadlines for ordering and effecting extradition will come into effect. The Secretary of State will decide the issue on the papers, taking account of any areas of dispute. As noted above, the context of the decision is an assumption that factual disputes can be resolved in the courts if necessary, and that the requested person will not be extradited, so on. And so it's a process which the Minister is well used to conducting, to decide matters on the papers. One sees the guidance itself recognises that the requesting states can also assist to ensure an accurate, sound decision is made by the provision of information. It also recognises that those competing states can seek to agree who goes first, and that's another step that wasn't taken here. And so, the case of Belhage, which unfortunately isn't in the bundle, I don't know how helpful the court will find this, but it does, paragraph 20, it defines terminology of cause and matter at paragraph 20, and I have copies if it would assist. And the cause is defined as a proceeding, civil or criminal, actual, prospective before a court, and a matter is something wider, namely a particular legal subject matter, although arising in a different proceeding. That is why criminal cause or matter in the Judicial Acts extends to judicial review in the High Court of a decision made in relation to actual or prospective criminal proceedings. This is why, as Mr. Edis QC, who appeared at the Secretary of State, felt bound to accept that even for the purpose of Section 6 of the Act, the judicial review of an extradition order would be a proceeding in a criminal cause or matter. On that footing, it seems to me impossible to contend that this judicial review was anything else. And so, contrary to the appellant's submissions, the fact that the decision determines which country the respondent stands trial in does not detract from the nature of the decision, because the focus is on the outcome. The outcome in either country is the same. The decision is analogous to other decisions taken by the Secretary of State, for example, to certify requests to order extradition, which are also criminal in nature. And so, to address my lady's point, that the requirement for directness of outcome does not preclude intermediate links in the causal chain between the decision of the Minister and the eventual trial. There are always multiple chains of decision in extradition proceedings, each of which is part of that criminal cause or matter. That is why Lord Wright was, this is what Lord Wright was getting at when he referred to the, quote, natural conclusion of the causal matter. So we have the Section 70 certificate of the Secretary of State, which is what triggers the matter being sent to the Westminster Magistrates Court. We then have the extradition order from the Minister that follows, and so on. And so, yes, so for the decision to have a direct effect on the criminal proceedings, a trial need not follow immediately. Hence, the judicial reviews of charging decisions are criminal causes or matters, or, yes, a judicial review of an order to disclose accounts of evidence in extradition proceedings in England for criminal proceedings in Sweden was a criminal cause or matter in Bonalumi, which is Authorities 2, page 366, tab 23. And the third reason I give for why this is a criminal cause or matter is because of the focus on the underlying proceedings, which the High Court has been asked to intervene. It is not an abstract categorisation of these proceedings themselves. The question is not who made the decision, but whether the outcome of the decision taken to its conclusion is open, which may result in jeopardy of awful punishment. It's not the form of the Minister's decision that is an issue, but the underlying extradition process that the decision impacts on and emanates from. That decision will determine where the trial will be, which may in turn impact on the form the trial will take. And so the post-McGuinness authorities consistently apply the Annan test. Cleland, the Judicial Review of the Criminal Cases Review Commission, the test of pending trial failed as it was after the trial and punishment has happened. And we've already explored the Guardian Media Judicial Review, which was The fourth reason I give is that the scheme of the Act is consistent with the 1960 Act, modelled on the criminal statute to ensure that there was only one appeal from the High Court, whereas the Minister perversely is advocating for an additional intermediate tier of appeal between the High Court and the Supreme Court, contrary to the purpose of an expedited appellate process, and contrary to the tenor of its submissions that delay should be prohibited. And so the equivalent judicial decisions of a district judge on competing jurisdiction, if I can just turn this up, it's section 44. So this is Authorities Bundle 1, at page 165. We have here competing Part 1 warrants, and that is where there's two different, the judge needs to decide between two different Part 1 warrants. And then there's also section 126, which is the competing extradition requests, where that's two Part 2. The Minister has to decide between two Part 2 requests.
Sorry, which section is that?
This is page 343 of the Authorities Bundle 1, section 126. Thank you. And the simple and rather obvious point I make is that both these decisions, the judge's decision on competing requests and the Minister's decision under 126, would also be challenged by judicial review to the High Court with no right to appeal to the Court of Appeal, which confirms the logic of the formulation I contend for. I submit it would be anomalous and inconsistent to allow a different form of appeal remedy for the same substantive issue, simply because the decision was made by a judge instead of the Minister. No one is seriously suggesting that a district judge's decision on competing requests would not be a criminal cause or matter and would have a separate right to appeal to the Court of Appeal. And so there has to be a coherence and consistency about the appellate rights, and that is what the scheme of the Act intended. And so other examples, there's many judicial reviews of judges, district judges' decisions that do not give rise to statutory appeal rights. So one example is section 36 of the Act, the case of Jane, which is referred to in the papers. The district judge's decision was challenged by judicial review, and it was accepted that that was a criminal cause or matter. There was no appeal to the Court of Appeal attempted. The High Court didn't certify a point of law, and that put an end to it. Salomon, where the adequacy of consent was an issue, is also another criminal cause or matter. And so, the fifth reason I give, the final reason, is that the High Court judgment of Mr. Justice Linden at paragraph 116 and 117. This is page 73 of the Core Bundle 1, accepted. And in fact, the appellant is recorded in the judgment as not disputing that the potential impact of a 179 decision is sufficiently detrimental to the requested person, the respondent, to give rise to a common law duty of fairness in making such a decision. In my submission, this illustrates the necessary jeopardy required for a criminal cause or matter being satisfied by the nature of the decision. And so, finally, I submit that the remedy lies to the Supreme Court. If the single judge certifies a point of law of general public importance, that application is pending before Mr. Justice Linden, but that's dependent on the certification stage and leave of the single judge or the Supreme Court if certification is given. And so, if the single judge considers as an important point of law, this has happened in cases such as Miklas.
He's presumably waiting on the decision of this court before he decides whether or not to certify.
Indeed, yes. But I simply say there's no prejudice to the appellant because its remedy is preserved. And so if I can then turn to the Minister's ground one, and the overarching contention, of the appellant is that there's a public policy need to achieve expedition and speed, and to avoid the floodgates opening with representations. And well, I've taken my lady already to the passage of the judgment where that was carefully addressed. These matters are properly monitored and dealt with by appropriate deadlines and procedures, and so there is no risk of any of that happening. But if I can just pause for a moment to explain, the context here is what's being recognised as a rare decision. So Ms. Justice Linden accepted and recorded the appellant conceding this rarity at page 78 of Bundle 1, judgment page 129, Roman 2, final sentence, and at paragraph 12.2 of this judgment, where he states it's not in dispute, these decisions are rare. And so it is an unusual situation whereby two countries both request the same person for trial at the same time. And so that's important in the context of what I may characterise as somewhat alarmist floodgate submission. Here, it's even more unusual whereby two countries are prosecuting the same conduct, but one of them, as part of that same prosecution, is also prosecuting more additional related conduct, additional offences. And so what matters most is the fair administration of justice in this situation. A lawful decision to be made, which must be well informed, which requires adequate information. A decision that's factually accurate. The decision here was not accurate because the Minister prevented the requested person from providing relevant information, didn't even tell him he was going to make this decision or when he was going to make it. This can include information about the protagonist, the person in issue, his circumstances, as they may be material even to the mandatory statutory factors. 1793A, the true scope of the prosecutions the Minister would have been assisted by. B, the place where each offence was committed, the nationality issue, applying his own guidelines, his own guidance. But also to the viability of the trial. And I've addressed the court on this already as to the importance of justice being done, family support assisting that process, and being material to the success of the process, both for the victims and the state, as well as the requested person. In circumstances where the requested person is in fact admitting his conduct and has already done so in Portugal. So the basic answer to the submission that the Minister should be left to act in a sealed vacuum of misinformation, in my submission, is the time-worn adage that of less haste, more speed. Had the Minister acted fairly and taken account of representations, he would have avoided misunderstanding the case. Errors would have been corrected, accuracy could have been assisted, could have assisted the process of reaching a lawful decision. Instead, we've had a lengthy process of the Minister trying to argue that it made no factual error and that if it had, it didn't matter, and so on. Then as to the duty to act fairly, see paragraph 116 to 118 of the judgment, the court recorded the Minister accepting the respondent's basic proposition that the potential impact of the exercise of decision under 179 was sufficiently detrimental to the claimant to give rise, at least in principle, to the duty to act, the duty to give him notice of her intention and to give him an opportunity to be heard before the powers exercised. Nor did the Secretary submit that there were special facts which meant the common law duty did not arise here. Rather, her principal submission was that that duty of fairness was excluded by the terms in the scheme of the Act. Now, here one goes back to the Howard League for penal reform case. What is required by procedural fairness will be sensitive to the interests of the person affected, the effect of the decision on that person's rights or interests, that is the seriousness of the consequences for that person. And so here the context includes the serious consequences for the respondent in the event of extradition to the US, given his accepted extremely high risk of suicide, the psychological deterioration, all points which Ms. Justice Linden recognised as important for the Minister to take account of. The decision also impacts support from the family, the professional institutional support as a victim of modern slavery, which to assist his recovery under Article 12 of ECAT. And here it's relevant to my submission that it's the same Home Office that has recognised these features of the case, the fact of his being groomed as a child, exploited as a child online, and all of the risks that gave rise to, as someone who was extremely vulnerable already and taken advantage of, and where the same Home Office is providing that support to help him get through that experience, all of which was essentially not part of that decision. So, yes. And so the non-exhaustive statutory 1794 criteria clearly permits other relevant issues to be considered. And so now the interested party for Portugal has helpfully set out the legislative history of Section 179 and the way in which it transposed Article 16 framework decision, which was titled Decision in the Event of Multiple Requests, into domestic law. It's clear from Article 16 that it requires a decision maker to give, quote, due consideration to all the circumstances, and especially the four matters in Section 179. And moreover, that TACA, Article 14, which is titled Decision in the Event of Multiple Requests, mirrors Article 6, the same Article 6 requirement to give due consideration to all the circumstances. See TACA Article 614(3), which addresses the situation where there are competing warrants and Part 2 requests, exactly what we have here. And there's a requirement to give due consideration to all those circumstances. The obligation here is for the UK to interpret its legislation in line with its international treaty obligations, and one would expect a coherent and consistent approach. And so I'd pause here to submit the Minister would may be hampered in its ability to give due consideration to all the circumstances if they deprive themselves of an important source, a relevant source of relevant circumstances, and a source that may be the only source of that relevant information on a blanket policy basis. The CJEU in OP confirmed that Article 16.3 required due consideration to all the circumstances of the case, so the decision maker cannot dispense with the need to give consideration to the interests of the person concerned. And in answer to the Court's question, clearly the Court is not bound by the case law of the CJEU, but the EU Withdrawal Act permits the Court to have regard to anything done on or after IP completion day by the European Court, so far it is relevant to any matter before the Court. And the Supreme Court, in the case of Lipton, confirmed that if a post-Brexit CJEU authority fits into the established line of EU jurisprudence, it may be highly persuasive. See the interested parties skeleton at section 38. And so ultimately the question is, was the duty to act fairly impliedly excluded by the statute Citizens UK? And the answer is that the Minister's position is mistaken and contrary to the authorities relied upon by the court below, by the Administrative Court. Any express reference to representations elsewhere in the statute does not displace the common law presumption of fairness, where a statutory provision is silent, especially given rights and interests of the person subject to competing requests and the consequences to them of the decision. Secondly, the statutory scheme as a whole is one that permits representations to be made, but with strict time limits. In fact, this has been the practice of the Secretary of State with respect to Section 93. Now, we were informed that actually the practice of the Minister has been to receive and accept and consider representations under Section 179. We served evidence that wasn't admitted before the Administrative Court to that effect. The purpose of it really was to invite the Secretary of State, pursuant to its duty of candour, to indicate if that is in fact true. And we would still welcome the Minister indicating if, in fact, it has considered representations on competing requests in the past. Because, and with great respect, Ms. Justin misunderstood the relevance of this evidence in the court below. It's simply because the Minister expressly told the respondent, when he asked to put forward representations, that it has not and does not receive or consider representations. Now, if that was a misrepresentation or if that was factually wrong, then it's important that is properly understood. But certainly from the bar, it's understood that it has happened before, and the Minister is well placed to confirm whether or not that's the case. And had we known that at the time, we would have relied on that. So it mattered because it would have affected how the judicial review process would have been formulated at the start by the claimant, if that was the case. Thirdly, the Thameside duty requires the Minister to take reasonable steps to inform themselves of relevant information necessary to answer the right question before making a decision. It dictates that the Minister must make due inquiry to act rationally. This ensures that the decision makers are fully informed, promoting better, fairer decision making.
That's right, but Thameside actually means that the decision maker decides what's relevant unless it's irrational to leave it out of consideration.
Well, yes. And
the decision maker is the arbiter of what is relevant in the Thameside context, and the administrative court doesn't interfere with that unless it can be shown that it's a Wednesbury unreasonable judgment call.
Yes, if I may, the submission I make with respect to this issue is that there were simple, proportionate, reasonable steps for the Minister to take to ensure that he had the most basic information before him, and he should have made sure that he had the US request and the Portuguese one at a minimum. And
was the Minister not entitled to rely on the fact that the civil servants had summarised the contents of those documents?
In my submission, no. For a decision of this importance, where the decision is predicated on precisely assessing those two competing requests, it would be irresponsible, the dereliction of that duty, not to be able to assess whether that summary is accurate or not. And due diligence requires that as a minimum. Yes, there's a further point that Ms. Justin made, which was that Section 93 doesn't enact a specific right to make representations, although it was mistakenly said this morning that representations may be made, nor an obligation to consider them. Instead, it's to set deadlines after which they need not be considered.
Well, it's implicit, isn't it, that there must be a right if you set a deadline beyond which you can't consider them. The two go hand in hand.
But it's relevant in my submission, my lady, that in the context of interpretation of Section 179, that there wasn't an express provision specifying the right to make representations.
No. I mean, you adopt Mr. Justice Linden's analysis, which is the fact that there are implicit in the statute the ability to make representations in certain contexts, but provided you do it within a limited period, doesn't mean that there isn't a similar right in other contexts. That's the basic point, isn't it?
Yes. Yes. Paragraph 119,
yeah.
Page 74. The next submission is addressing whether it's impossible, impractical, or pointless. And that is the submission that's been advanced as a basis to exclude fairness to the requested person. I should mention that the reliance by the appellant on Navadunskas is misplaced in my submission. There the court was addressing an application to reopen an appeal or to judicially review the decision of the National Crime Agency not to consider human rights grounds. That entire issue has been resolved by the legislative change, which is a system that functions perfectly well in terms of supervening human rights developments. But basic point I made, paragraph 122 of the judgment of the High Court, page 76, the judge dealt with this submission comprehensively. He afforded it due weight and simply observed that deadlines can be set by the minister to avoid delay but to achieve justice. And obviously the Supreme Court in Bank Mellet was clear that as a general principle, the court should be slow to make a finding where the statute is silent on the matter. And the judge's analysis was consistent with this principle. So,
I'm not sure that Ms. Ailes is saying that it would be impossible, impractical or pointless. I think she accepted that if the interests of your client in this case are relevant to the decision, then the Secretary of State would have a common law fairness obligation to receive representations. What she's saying is that the personal interests of your client aren't relevant, which is a matter of statutory construction, I think, under Part 1 of the Neuberger definition in Bank Mellet at 179.
Well, with regards to that, my Lord, I again rely on the judgment of Justice Linden, who found that the sections 44, 93, the provisions that permit representations, permit submissions to be put across, should not be applied inconsistently with 179. And so where there's a judicial process for competing requests to be determined, a hearing will take place, the judge will hear competing representations. Why should someone be prejudiced by a different system of unfairness, which is entirely different to that which they benefit from simply because there's two competing Part 1 warrants being determined? That doesn't bear scrutiny in my submission. Yes, and so the submission that the judge, by the appellant, that the judge failed to take into account the argument that a requested person's individual circumstances should be made in the statutory appeal process. I think I've probably addressed the court on that sufficiently already. I just emphasise it. It's Section 179 involves a comparative evaluation.
Yes.
Yes. Thank you. Yes, the further point I wish to make is that the Minister does accept that it can receive representations from the states, from the competing states, when reaching a decision under Section 179. It's a matter for the state, if necessary, on receipt of information from the other states. And there's Commission skeleton argument from the 2nd of October 2025.
You say, well, if you can hear representations from the states, then why can't you hear representations from the person it most affects, which is the individual?
I do, yes, thank you. Well, and yes, and so the request person should, if there's misinformation or an error contained in those representations, it would be contrary to natural justice to deprive the requested person of having the opportunity to correct those representations. And so there has to be a fairness about that process. Yes, lady, I'm conscious of the fact that learned friend Miss Foote is dealing with the factual errors and needs some time to address that. The interested party is also addressing the court briefly on the issue of EU law, and learned friend needs to have some time to respond. And so, in the circumstances, given the comprehensive written submissions, court may consider that I've said enough in reply. Unless
very clearly set out your stall, if I may say so.
Well, I'm grateful. I don't propose to take up more of the court's time at this, unless there are particular questions that I can assist the court with at this juncture.
No, not for me, thank you.
Thank you very much indeed. Yes, Miss Foote. You're going to tell us that the judge was right for the reasons he gave.
That's right, my lady. And I can deal, I should say, with ground 3 in relatively short order, partly because the court's already been helpfully taken to most of the underlying materials before the minister. But in summary, of course, it's the respondent's position that there are no errors of law in the judge's analysis of the first 2 mandatory statutory considerations in section 179. Firstly, the relative seriousness of the offences, and secondly, the place in which they were committed. And of course, it's right to say that it may well be that a different judge may have taken a different approach, but there's simply no legal error in the judge's analysis. The court will already be aware that there were 2 errors of fact which the respondent contended were evident in the materials before the minister, and therefore the manner in which the minister reached the decision. The first relates to the presentation of the underlying offending between the request and the warrant as identical. Of course, it's accepted by the Secretary of State that it's not identical, but the issue really is about whether or not the error was material and whether or not there is additional conduct arising in the Portuguese warrant. First of all, just to illustrate what in my submission is the materiality of the error, it's instructive to look again at the materials before the minister. So I'm looking first of all at what's called in the pleadings as the true Annex B. So that is one of the materials attached to the submission. And I'm looking in particular at page 9 of that, in which it said, under paragraph 10...
Are you able to give us a reference to that, please?
Apologies. Page 9 of, I think it's the supplementary documents bundle.
Thank you.
It's tab 1B, I think.
Yeah. Yes.
And so paragraph 10 is entitled Key Points for Consideration.
Yes.
And one can see at the bottom of that, just before the second bullet point, that it said, as such, with the information available and given the identical facts, we are unable to fairly determine which request is relatively more serious, and we must consider whether the other matters are determinative. So that is what the judge described as the mistaken assumption that it was a dead heat between the 2 sets of offending. So that itself illustrates the materiality of the minister's error in my submission.
And this is because of the failure to take into account the money laundering and the tax?
Yes. 2 offences which, it's not in dispute, appear in the Portuguese warrant and not in the request. If I can just deal first of all with the money laundering, because it was contended earlier that that arises from the same conduct as the cybercrime. And I'll come in a moment to the issue of the Norris test and conduct and whether that applies. We say it doesn't. But I wanted to briefly turn to our skeleton argument before the judge, just because the issue I want to refer to is summarised there in relation to the money laundering. So yes, for the court's reference, I think it's the core bundle, page 176, and it's one of the submissions in relation to material considerations, paragraph 73. And what that paragraph summarises is the fact that the value of the proceeds of the respondent's crime is significantly greater in relation to the money put into his bank account in Portugal compared to the financial value of the offending that's contained in the US request. Again, just for the court's reference, because those are the old bundle references there, the Portuguese warrant is in the supplementary bundles document, The material part is at page 93. And one can see there the list of deposits into the Santander account based in Portugal. And on the sums I did at the time before the judge, it amounts to significantly more when it's converted into dollars than the amount in the US request. So that, of course,
more than 3 times.
Yes, and that goes to the location of the offending as well as the issue of victims, of course, because the offending took place in Portugal with the money gained put into the Portuguese bank account. Secondly, as has already been canvassed, there's the allegation of tax fraud committed against the Portuguese state. That's been referred to earlier. It's at the bottom, insofar as the Portuguese warrant is concerned, it's at the bottom of the same page, where it's said that the respondent has never been fiscally registered for engaging in any business activities and has not submitted any income tax declarations. So in our submission, that is additional offending based on the additional conduct, failure to register with the tax authorities. And as your ladyship is aware, it's our submission that the judge was right to say that the difference between the request and the warrant was one of substance and not of form. It may well be that the cybercrime offences, which are common to both the warrant and the request, do arise from similar conduct, but the point is that there is additional offending behaviour alleged in Portugal such that the scope of the Portuguese warrant goes wider than the scope of the US request. In our submission, the judge encapsulates and summarises that effectively at paragraph 149. I won't read it out, but in effect, it's a highlighting of the error by which it was thought wrongly by the minister that, as far as the seriousness of the offences were concerned, he was looking at two identical requests from two states. That's plainly materially wrong. And there's another reason that the judge considers, which in our submission meant he was right to conclude that the error was material, and that's at paragraph 150. And this relates to another consideration, not one of the mandatory statutory considerations, but a further consideration under the Secretary of State's policy. You were referred to that earlier by Ms. Townsend. I'm looking at the document at 157 of the supplementary documents bundle, although it's materially the same as the document earlier. So I'm looking at paragraph or section 7 of that, matters which may be taken into account, where the decision as to precedence is not settled by the relative seriousness of the offences, which was the mistaken assumption here. And at subparagraph 3, it's stated that a material consideration in accusation cases, as here, is the extent to which conduct alleged in a request or Part 1 warrant is subsumed in a competing request or Part 1 warrant. Well, that's exactly the case here.
Money laundering might well be, but the tax evasion not necessarily.
Quite.
What do you say to the point that was made that the tax evasion wouldn't have been the subject of an arrest warrant in and of itself if it hadn't been for all of the other criminality?
The point is simply that the conduct alleged is wider, and it's an additional offence in relation to which the respondent will receive an additional penalty in Portugal. It's relevant to seriousness and it's relevant to location. The second material error of fact is in relation to the location of victims.
Yes.
And I won't reiterate the places.
You say
in
the
which,
Portuguese state
yes,
is the victim of the tax fraud.
Yes. But just on the issue of the victims of the cybercrime for a moment, it is material in my submission that the US request itself refers to victims of cybercrime not in the US. For the court's reference, page 25, paragraph 5 of the supplementary documents bundle.
Well, it envisages that there might have been victims abroad.
Yes.
With abroad from the US, but it doesn't quantify how many or where, and it certainly doesn't envisage them being in Portugal.
No, I just wanted to emphasise that the underlying materials themselves are not quite as clear-cut as was suggested to the Minister.
Yes.
And similarly, the Portuguese warrant refers to victims often being in the US and victims being in the US and abroad.
Yeah, I mean, in terms of the competing jurisdictions, the evidence tends to point to the preponderance of the victims being in the US, insofar as there's any information as to where they are.
Yes, I don't think that's in dispute. It's a question of the Portuguese state and the location in addition. And just further, although it wasn't before the Secretary of State, it would have been had Portugal been given the opportunity to make representations. The matter is dealt with in the letter of the prosecutor, the Portuguese prosecutor, Edis Pino. For the court's reference, this is the core bundle at page 146, paragraph 12, which is related to the victims of the cybercrime, actually, and which it said towards the end of that paragraph that the impact of the exfiltration of personal data was echoed worldwide, above all because raid forums publicised the sale of such data in an open source, which is why international cooperation with countries such as Sweden, Romania, Germany and the UK was promoted. And again, that would, and we say, should have been taken into account had representations been permitted. So that overall in our submission, the judge was quite right to find a material error of fact in respect of the location of victims. Just in a response to the submission about an impermissible hierarchy, in our submission no such hierarchy was imposed. Rather, what was conducted was a careful and context-specific analysis of the extent to which the location of witnesses in a case such as this could have been particularly material, because what the judge says at paragraph 155 and 156 is that because the nature of the offending was cybercrime and therefore the nature of the witnesses are law enforcement witnesses, not the sort of witness that's tied to a particular location, such as an eyewitness. And also because paragraph 156, the evidence of those law enforcement agents could be shared with Portugal. And moreover, Portugal had conducted its own investigation, presumably with its own law enforcement witnesses.
That point about covert surveillance and whether that may or may not be admissible in Portuguese proceedings.
There is that, my lady, but the point is simply that it's not that the judge is adding his own hierarchy to the statute, but just that in the context of this case, taken together, the errors were material to the two statutory criteria.
Yeah.
And I'll invite the court to read paragraph 157 in conclusion. I won't read it out because that summarises the position. Just very briefly, in terms of other errors that it's submitted were conducted by the judge. That's dealt with at paragraphs 75 to 77 of our skeleton argument. The issue of the respective timing of the request was raised earlier, with the complaint made that the judge hadn't adequately considered that. Well, all that matters is that the minister had, and it was noted correctly, that the US request was first in time. Secondly, it suggested that the respondent's nationality was not considered.
Well, these are all points that, as I understand it, you say are points that would be for the Secretary of State. But the question is, was the judge right to decide that the errors were material?
Well, yes, and
they're apples and pears.
He was. And the issue at paragraph 165, insofar as it relates to nationality, is a finding by the judge that what was wrongly not taken into account for the reasons he found in ground 1 were the respondent's interests, matters inextricably linked to nationality.
Well, that is inherently bound up, isn't it, with the rightness or wrongness of ground 1?
Well, yes, but there's no separate error in relation to nationality. My lady, unless I can assist further, that completes what I wanted to say in response to ground 3.
Thank you very much. Now, who's going first? Mr. Evans?
Yes, thank you. The first interested party, Government of the United States, makes 2 very brief points.
Yes.
The first is that in terms of jurisdiction, the first interested party agrees with the applicant's analysis. And the second point is that no submissions are made about the legality of the applicant's decision-making process, and the first interested party remains neutral in relation to the arguments advanced.
Thank you very much. Mr. Hyman.
My lady, good afternoon. I'm afraid that I'm going to take slightly longer than Mr. Evans, as you will have seen that Portugal has descended a bit more down into the arena than the US government. I don't take a position on jurisdiction, I leave that in the court's hands.
Yes.
There are 4 brief points, perhaps 2 are briefer than the other 2 points.
Yes.
The first point, if I may, relatively shortly explain the interest of the Portuguese judicial authority in these proceedings and why I have descended perhaps down more into the arena than my learned friend. The Portuguese state clearly takes an interest in the welfare of its own national, and the court may think it's rather noble it takes such an interest, and it is not necessarily meddling in the applicant's process or procedure. From Portugal's perspective, the crime was committed in Portugal. The claimant was physically located there. It seems almost all of the time. There's very limited evidence that he may have been in. Well, I don't think he was in the US. The tax and revenue offence, as you've heard from my learned friend, is owing to the Portuguese state, and assets have been seized in Portugal pending determination of the criminal proceedings there. And based on those facts, that is why Portugal has such a strong claim in its respectful submission to jurisdiction. In a second, I'll turn to the construction of 179 and the EU law point, but just to explain, since I think it came up in Miss Ayles's submission, about why Portugal has a particular interest within the European space, so I can put it that way. I don't just mean EU, I mean European space, is because as a matter of EU law, and this never directly applied to the UK when we were a member state, there is a principle called proceedings, which is set out at paragraphs 43 to 47 of my skeleton argument. It's also Mr. Justice Linden's judgment. Many EU member states, prior to the European arrest warrant, would not extradite their own nationals to each other. France and Germany had to change their laws. Germany had to change its constitution, in fact. And so there is a principle in EU law that since Portugal has a nationality bar, and let's say you were rewinding 6 years and the UK were an EU member state, because Portugal wouldn't extradite its own national to the US, if a British national was detained in Portugal, the Portuguese authorities would, under the law, have to give Britain the opportunity to decide whether it wishes to prosecute its own citizen, and if the UK would have issued a European arrest warrant, back 5-6 years ago, as a matter of EU law, the European arrest warrant would have taken precedence. you would have seen that my lay client, the Portuguese prosecutor, has made some quite direct submissions on this point. I can't adopt those submissions, my lady. I can't say Petruchan applies to the UK because it doesn't. We're not an EU member state, and it wouldn't have applied anyhow because the UK doesn't have a nationality bar, as we know from Lord Burnett and quite famously in Love. And so I can't advance that submission before you. The only point that I have put at paragraph 48 of my skeleton, which is as far as I can take this point, is that there are a couple of CJEU cases called Alchester 1 and 2. I believe my then friend Miss Els is representing the UK government, which still has a right to appear in some CJEU cases. And the height of my point is that in that judgment, the Grand Chamber recognised that we weren't an EU member state, we weren't an EEA member state, but there was a special level of cooperation between the United Kingdom and the European Union. If I may say, we weren't just any third country, given the strength and depth of the trade and cooperation agreement, including in judicial cooperation in criminal matters. Yeah. And that may be relevant when I turn to my next point, my lady, which is in relation to 179 of the Act. The court would have been taken to 179. May I emphasise that prior to the 2003 Act, there was no provision for choosing between competing extradition requests. It wasn't, as I understand it, in the 1989 Act or any of the preceding extradition acts enacted, the Fugitive Offenders Act, I think it's 1965. 179 is a transposition of EU law, and the UK, of course, had an obligation to transpose Article 16 of the Framework Decision into UK law when the 2003 Act came into force. Article 614 of the TCA, to which you've been taken, is the mirror provision of Article 16 of the Framework Decision. And that imposed two obligations, or those that imposed two obligations on the UK. The first is Section 45, so competing EAWs or arrest warrants, and Section 179, which is an extradition request versus a European arrest warrant and an arrest warrant. I disagree with Miss Els' submission on the construction of Article 614 TCA. I'm not sure if it would be helpful to pull that up. It is in the, sorry, I'm being greatly assisted by my learned friend. It's in, I think it's page 50 of the part 1 of the authorities bundle.
50.
Yes. It says decisions in the event of multiple requests. If two or more states here is either the European Union member states or the United Kingdom, it doesn't say member states there, have issued a European arrest warrant or an arrest warrant, and that arrest warrant there is a TCA arrest warrant. It can only be a TCA arrest warrant, and actually arrest warrant isn't actually capitalised in Title 7. If the court were to look through Title 7, you'll see it doesn't tend to be capitalised, although the EU and European arrest warrant is capitalised for the same person. Decision as to which of those arrest warrants, and those arrest warrants are either the European arrest warrant or the TCA arrest warrant, is to be executed shall be taken by the executing judicial authority. So here that would be the DJMC at Westminster under Section 45 of the Act, with due consideration of all of the circumstances. The court has that point from the submissions made earlier, especially the relative seriousness of the offences, etc., etc., etc. But there's a carve-out, if I may use that term, about the legal obligations of the member states. Now that is a specific carve-out. The use of the word member states there clearly means it's only applying to the EU member states. Yes. It can't apply to the UK, and that's codification of the Petruchan principle. The reason it doesn't appear in the framework decision, of course, the framework decision's 2002, Petruchan's 2015, and the court
Is it only the codification of Petruchan?
Well, because it is deriving from the union law, in particular freedom of movement and discrimination grounds of nationality. Petruchan is decided on those parts of the TFEU.
Right.
Except because it would affect the freedom of movement, because of discrimination between those states which have a nationality bar, those don't have a nationality bar, and that could affect free movement between the member states. I'm not going to take you to the authority. I think it's in Mr. Justice Linden's judgment. That hasn't been codified into the framework decision because the member states they can't agree to amend the framework decision. It's a thorny issue, as the court will know.
Yeah.
But Petruchan's 2015, and so this is the codification of Petruchan. The execution judicial authority may seek the advice of Eurojust. And here, sub-article 3 is, in the event of conflict between an arrest warrant and a request for extradition presented by a third country, so in this case, decision as to whether the arrest warrant or the extradition request takes place shall be taken by the competent authority of the member state. I would suggest, and I can take the court to OP in a second, that this is singular. Not the competent authority is the member state, but the competent authority is either Secretary of State, the administrative, or a court could, a country, I've got to be careful not to use the word member state, could decide to vest that power in the court if it wanted to. It could be a judicial authority. The UK, when transposing...
UK decided not to.
To put it in Secretary of State, and that's absolutely fine, and that's been consistent from the European Arrest Warrant Framework Decision to the TCA. And then, of course, it cross-referenced back to the factors in paragraph 1 of Article 614. And so, in respectful disagreement to the Secretary of State, we say that this does apply to the UK. We are a state for the purposes of subparagraph 1 until the Petruchan carve-out, and that obligation as a matter of EU law was transposed into section 179, and although we are outside the EU legal space now, there continues to be an international obligation to interpret section 179 consistently with Article 614 of the TCA. Turning now, if I may, to the one case brought to the court's attention, and that is OP on which Mr. Justice Linden relied. And I may just take the court to OP very briefly, not to the Advocate General, but to the Chamber's decision. It's always difficult to work in authorities bundle. Page 310. 310 of the second one, please. I agree with.
Yes.
I agree with my learned friend's summary. It's a French judicial authority which is rather upset that the Spanish authority has preferred to extradite a French citizen to Switzerland as opposed to executing the European arrest warrant that this is issued, and so it posed a question to the Court of Justice about the legality of this mechanism.
And has France got a Petruchan bar?
Yes, France has a nationality bar. And the first point that I would take the court to paragraph 41 of the judgment, which is page 319, which is interpreting 16.3 of the EAW framework decision. There it says all of the circumstances in the case, particularly, in particular those in Article 16.1, and then it enumerates them, and it would suggest that the factors there aren't exhaustive, but also paragraph 45 of the judgment states that the competent authority, again, I would respectfully suggest it's a matter of EU law, it would suggest it is one competent authority, not the Secretary of State's submission in this case, which appears to be, we don't do human rights, that's for the court. So it's dividing the responsibility between the administrative branch and the judicial branch. And it says, must give due consideration to all the circumstances in the case. That authority has broad discretion when making its decision or precedent. But the fact remains that it cannot dispense with the need to give consideration to the interests of the person concerned. So I would suggest, as a matter of EU law, that the competent authority, the body that is deciding, has to take account of the rights of the person concerned, and that would be under, as Ms L says, the Charter of Fundamental Rights of the EU, but that's effectively, in terms of Article 8, what we would say that's obviously sends.
How do you square that with the fact that that Parliament has decided to exclude consideration of human rights from anything that the Secretary of State does?
My lady, I'm going to have to dodge that question, because the Portuguese Judicial Authority's position is we can't necessarily meddle with the innards of it.
No.
And so I know
you say there's a certain tension between them that we're going to have to resolve it.
Yes, I think that's as high as I can put my submission. Unfortunately,
but you say just as a pure matter of EU law,
yes,
it's very clear that whichever authority is designated as the decision-making competent
yes,
authority, which could be executive or could be judicial.
But we suggest it's singular. I think that's as far as I can go.
Yes, but it is a singular authority, has to take into account charter rights.
Yes, and that is the height of my submission. In terms of what is the status of this case, it's Section 6(1) of the European Union Withdrawal Act.
Yeah.
The court can take account of it. I would gently suggest, like I would do on behalf of Portugal, I know, that given it's the same statutory scheme, given it seeks to fulfil the same purpose, and given that I would suggest to submit it is perhaps something that the court will, well, Mr Justice Linden was fortified by, I would say it could perhaps go a bit further than fortification, but I don't take that point any further.
Right.
The other 2 points that I've made in my skeleton argument are that this is consistent with other EU law instruments. I've drawn the court's attention to a new regulation where there's a specific article with regards to the interests of the person,
yeah,
and also the Eurojust guidance, which was mentioned in Mr Justice Linden's judgment. The UK continues to participate in Eurojust. We're not a member state, but there's a cooperation agreement between the Home Office and Eurojust, and we would say that guidance is still material, if not binding. There is, I would say, a wider point as well, is that the Portuguese JA has no standing in the statutory appeal against the extradition order. So I can't be represented at, sorry, the Judicial Authority
yes,
can't be represented. It's a bit like for the Court of Appeal Criminal Division, there's no provision in the Extradition Act to hear interested parties, like a judicial review case or for this court even. And so it would be difficult to know how the Judicial Authority could make submissions on human rights issues, but not feeding them through the requested person, and how the court would take those into account. And of course, I think the point's been made by my learned friend Mr Cooper, King's Counsel, that of course it could be perfectly possible that the requested person's extradition to the US is compatible with Article 3 and 8, but that's not the question. The question is which extradition request should take precedence. And so it's almost asking the wrong question of the human rights issue.
It's Mr Cooper's basic point about one's carrying out a comparison, and you've got to carry out a comparison on all relevant material and not just some.
Yes. That would be my second point. My third point was to adopt ground 3, my learned friend's submission, so I don't say anything further. My lady, you would have seen from the additional documents supplied by the court, this is under the duty of candour, I'm not speaking, that he, Mr Santos Coelho has been indicted, that indictment has been accepted.
Yeah.
So I would imagine that it fulfills the statutory requirements in Portugal, and his case is set down for trial later this month, just so the court is apprised of the full facts.
Right.
The final point to draw to the court's attention is the fact that I think you were taken to it by Mr. Cooper, actually forgive me, I think it was Ms. Foote, about the Secretary of State's policy. It says, if I may just take you to page 157 of the supplementary bundle, very short point. It's called Binder 2 in the electronic version.
157.
Please.
Yeah.
It says in paragraph 8, where the decision is not clear-cut, it may be necessary or worthwhile asking specific questions from the states concerned.
Yeah.
And I don't mean there's any disrespect, we weren't invited to make any submissions, and as you can probably tell by the tenor of the submissions made, there is a forceful claim to jurisdiction in this case.
Yes. Just if you can, so I've got a complete handle on what's happening. Does that, you tell me his trial's been set down for later this month. In terms of the practicalities, does that mean that there's a possibility that he'll be tried in his absence?
As I understand...
Because he's still here, as I understand it.
Yes, he's bailed to be here and he can't leave the United Kingdom. As I understand it, it is said that he will participate over video link.
I see.
Trial.
Right.
For that trial. I can't provide further information.
Right.
I know that he is legally represented in Portugal.
Yes.
So he wouldn't be, without going into section 20 of the extradition
no,
of 2003, but if one is legally represented, one is not absent. In terms of the practicalities of how that works and what happens at a Portuguese trial, I'm afraid I can't.
But there is a very real risk that this decision is not going to come out before he's tried.
Well, I don't know when the decision will be taken, because of course it's not a jury trial in Portugal. There'll be a judge. Well, it would depend on what position he were to take in the criminal proceedings. And
of course, and you say that he's made a number of significant admissions, and therefore he might be effectively pleading guilty.
I can't assist you with that. If he were to accept criminal liability and there were to be a final judgment, the conviction would become entered in the record, and assuming that any appeal rights. Again, I'm just...
Yes, this is all hypothetical. I'm just thinking about the practicalities.
Well, the practicality would be that there would have to be a replacement of the TCA arrest warrant for a conviction arrest warrant.
Yes.
For purposes of prosecution, and one would imagine that my learned friends in front of me would be seeking to amend their appeal notice in the High Court to plead a further ground, which would obviously arise on these facts.
Yes.
But that's all supposition.
Yeah. Well, it's been very helpful. Thank you very much. Sales. One thing I think might be helpful is we were taken to a couple of provisions of the statute where other decisions were going to be taken on competing matters.
Yes.
One by the Secretary of State, the other one by the district judge. And Mr. Cooper makes the point, well, in those cases, there shouldn't be a difference in quality, in terms of the position that obtains under those provisions from the one that obtains here.
Yes, I don't immediately have instructions on the extent to which representations are received on those points.
Right.
Well, they're likely to be. Section 44 is a decision for the district judge, I think. Section 126 is very like Section 179. It's a decision for the Secretary of State.
Yes,
so the judge, at least, is probably quite likely to receive representation.
Oh yes, no, I mean it is certainly the case that where you're dealing with competing Part 1. I'm sorry, I may have slightly misunderstood my lady's question.
I may not have put the question as clearly as I should have done, but my lord has spotted the point.
Where the issue is competing Part 1 warrants, that is dealt with by the court. That reflects what Section 6141 says. It's a judicial authority. And yes, it's my understanding that the practice is that the court does invite submissions. Really, the point that we make about that is that's a matter for the court.
Yes.
It's not obviously the Secretary of State respects the independence of the judiciary and doesn't interfere in that process in any way and is not a party.
I think is it a relevant one is 126. Sorry.
Is it a criminal causal matter?
Oh, I see. It certainly doesn't follow logically that it must be, because there are certainly plenty of decisions. There are some authorities on bail, for example, in the bundle, where you have a judge sitting in a case with a prosecutor and a defence counsel, where it has been held to be collateral. On the logic of my submissions, I would say that this extends in the same way. I would not necessarily accept that if my Lord is against me on that point, that it follows that my other submissions on jurisdiction also fail.
Understood. Thank you.
What about 126 though? Because that's much closer. And it is the Secretary of State taking the decision. That's competing part 2, isn't it?
Yes, just excuse me for a moment. Yes, there is no practice of receiving representations from the requested person. There may be representations, and there is an opportunity to the extradition partners.
So very similar.
So very similar. Yeah. And may I add, given that Mr. Cooper raised the point that on instructions, insofar as memory allows, given turnover of staff and so forth, but we're not aware of any instances of representations from requested persons being accepted under section 179.
Yes.
On my Lord's other point, which is as to the status of the decisions of the Court of Justice of the European Union, there is, I believe, a carve-out for decisions where the United Kingdom is still permitted to intervene. But the general position, which applies to OP, we submit is Section 6 of the European Union Withdrawal Act 2018. A court or tribunal is not bound by any principles laid down or any decisions made on or after IP completion day, which is the end of 2020, by the European Court. And then skipping ahead, a court or tribunal may have regard to anything done on or after completion day by the European Court, so far as it is relevant to any matter before the court or tribunal. While I'm on that act, also of relevance perhaps to the submissions that have just been made, is that under section 5.4 of the Act, the Charter of Fundamental Rights is not part of domestic law on or after IP completion day, and I appreciate my learned friend isn't making submissions on UK domestic law, but I draw that to your attention.
Well, it ever was it? I mean, we've got the European Convention rather than the Charter.
So far as Mr. Cooper's submissions are concerned, just one point, he raised the case of Belhaj, which is not in the bundle. Can I just draw the court's attention to the fact that that is addressed in McGuinness? Yes. The reference is 483, paragraph 24. Essentially, the point is caution is required. It's not a case about appeal routes.
Yeah.
and in relation to Mr. Cooper's submission that justice should be done without delay, I will stop there.
Oh, any other questions? No, well, thank you all very much. Our thanks to Council and to those sitting behind them for their comprehensive submissions. We will obviously need to take time to consider them. This is an important case, important obviously to Mr. Coelho as well. We'll try to get you a decision as soon as we can, but there are no guarantees that it will come out before he faces his criminal proceedings in Portugal. I fear that may be very unlikely, actually, if he's facing a trial later this month. And I'm sorry about that, Mr. Cooper. Obviously, this court recognises the difficulties that he is facing. We are not unsympathetic, despite the fact that we have robustly tested some of the assertions made on his behalf. We will circulate our judgments in draft in the normal way for normal corrections, typing errors, any obvious factual errors, but not the opportunity to re-argue the case. And obviously it will be handed down remotely and you will get copies. Make sure please that my clerk has everybody's email address so that it can be circulated to those who need to see it under the usual embargo. So that includes anybody in government who needs to be consulted in relation to the outcome, and of course anybody on Mr. Cooper's side who needs to see it as well. We just have to emphasise that the embargo on dissemination of drafts is very strict and taken very seriously by this court, but I don't need to tell counsel that. You all are well aware of that. And it just remains for me to say very great thanks to all of you for finishing the case on time.
Geraldine,
yes.
Could we just ask to be kept informed about what happens in the criminal proceedings in Portugal? It doesn't matter to the appeal, but I'd like to know.
Okay, Lord Justice Edis has suggested, and I think it would be very helpful, please could we be kept informed as to what's going on in Portugal? Informally by email will be fine, addressed to my clerk, and then it can be disseminated to the other members of the Constitution. Yes, we'd just like to know what is going on in Portugal, if that's all right. Yes. Thank you very much.
Court is able.